New Revolution Institute presents Your Call to Active Citizenship. This is Lesson 2, The Purpose and Role of Government, Part 2. Now this lesson is going to cover 1. Checks and balances, 2. The legislative branch, 3. The executive branch, and 4. The judicial branch. And now here's your teacher, Matt Staver.
When our government was founded, the founders understood that there is a nature of humanity that wants to color, if you will, outside the lines. It's the sin nature that we clearly understand, this rebellious nature that needs to be checked. Obviously, as individuals, we need to be self-restrained in this republic in the United States of America. And that self-restraint comes because of a moral understanding and a moral restraint. And that morality comes from Christianity and our Judeo-Christian worldview. But when we form the government, it's just a magnified composition of individual humanity. So knowing that, the founders realized that as they formed this new government, the United States of America, and they formed the governments in the individual states, they had to do something to check that nature of sin, that rebellious nature that always wants to take more power and become a dictator, if you will, over someone else. So they came up with the idea of checks and balances so that we would have 3 branches of government. The legislative branch, which is the repository of the power because that is the people, and the people create the laws through their representatives. They loan power that is theirs to the government to protect them and protect those pre-existing God-given unalienable rights. And then there's the executive branch. The executive branch is the enforcer of the laws. The legislature creates the laws, but the executive enforces those laws. And then, as created, the weakest branch of the government in its founding era is the judicial branch. It's a branch that cannot create laws, and it cannot even enforce laws. It only decides cases and controversies that come before the court with respect to a violation of the laws passed by the legislature. And then once the court issues a decision, that decision is enforced not by the legislature and certainly not by the courts, but by the executive branch. These 3 branches of government all work together, and they check and balance each one. There's no one branch that has all of the authority. Although the repository of a lot of authority is in the legislative branch, there's also authority that it can't exercise that is exercised by the executive branch. And there's authority that the executive branch can't exercise because it's exercised by the judicial branch. Now, Thomas Jefferson said that the judicial branch was the weakest branch of all. In fact, for most of American history, the judiciary at the United States Supreme Court, the highest court in the land, didn't even have its own building. It met in other buildings on Capitol Hill. It wasn't until our modern history that a separate standalone building, now we know as the United States Supreme Court, was created. And the reason for that is because it wasn't considered to be a very powerful branch of government. The most powerful and most visible is the legislative branch in Washington, D.C. But over time, Thomas Jefferson feared that the judicial branch could ultimately usurp the power of the other branches. And if it did, it would ultimately result in potential chaos and the dissolution of the republic. I think we experience some of what Thomas Jefferson feared today. The Constitution of the United States says this: "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." And then Article 1 sets forth the legislative branch. "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives." Within the legislative branch, you also have a division of powers. You have two houses. You have the United States House of Representatives and the United States Senate. The one that is closest to the people is the representatives. That's why their terms are only 2 years. That way, they constantly are running for re-election and therefore responsive, or should be responsive, to the people in their constituency. The other thing is that there's more of those representatives than there are senators. These individuals are based upon the population of the individual state. So some states will have more representatives than others based upon their population. So they represent a smaller part of their state, and their term is only 2 years. That is a particular part of the legislature that is responsible for the creation of certain bills. For example, only taxation bills can come from the United States House. They cannot originate in the United States Senate. They must come from the people. So if the people are going to have another tax or an additional tax, it needs to come from the people and then move to the Senate, not comes from the Senate and moves to the people. There's other things that are residing in the U.S. House that do not reside in the United States Senate. When you move over to the Senate side, the Senate is comprised of 100 individuals, 2 senators from each state. No matter whether it's California, New York, or Florida, or Delaware, or Rhode Island, each state has the same number of senators. Each state has 2. So in that respect, they're put on equal footing. This particular body has 6-year terms, and the purpose of it is to be a little bit more deliberative. Sometimes we look at potential gridlock between the House and the Senate, but in some cases, the debate between the two can be good. Obviously, complete ideology that separates the two, for which they can't get anything done, is not good. But the idea is that the House and Senate have 2 different functions. And so, for example, there are certain things that the Senate can do that the House cannot do. When the President nominates someone for a position such as a Justice of the United States Supreme Court, it's the Senate that gives advice and consent to confirm that nomination, not the House. So Article 1 sets forth Congress between the 2 different houses that are divided in their power and the different functions and roles of each legislative body, so that even within the legislative branch of one of the 3 branches that we talked about, executive and judiciary, there's a division of powers even within the legislative, because it is this particular body, the legislative branch, that has the repository of the creation of laws. And what we have in the United States Constitution between the 3 branches of government, legislative, executive, and judiciary, and then the breakdown of the House and Senate, is the same kind of setup that we have in all of the other 50 states. Article 2 of the United States Constitution talks about the executive branch, and this is what it says. The executive power shall be vested in a President of the United States of America. He shall hold office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. And it goes through how the President of the United States is elected. The President, or the executive, the chief executive officer, if you will, of the United States of America, is like a governor on the individual states, set up the same way as typically the head of that particular body of government. The President is the head of the executive branch. The executive branch is the enforcer of the laws. Without the executive, the laws that the legislature passes could not be enforced. Without the executive, the rules and rulings from the courts could not be enforced. So, for example, a court in the judicial branch could issue a ruling, but it's not worth the paper that it's written upon unless the executive enforces it. The executive is the enforcer of all of the laws. The executive, just like the legislature, has a duty to take an oath to the Constitution and to interpret and apply the Constitution accordingly. They don't necessarily lay down their ideas at the altar of the legislature. They have an independent duty to make sure that they are operating in conformity and consistently with the United States Constitution, because outside of the Constitution, they have no powers. The third branch of government is the judiciary, the federal courts, or in the states, the state courts. Article 3 of the United States Constitution sets up the judiciary. It says, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish." It goes on to say that judges both of the Supreme Court and inferior courts shall hold their offices during good behavior and shall at stated times receive for their service a compensation which shall not be diminished during their continuance in office. Now that's speaking about the federal branch of the judiciary. There's only one court, interestingly, that is required by the United States Constitution. Just one. That may surprise you, but the only court that's actually established by the United States Constitution is the United States Supreme Court itself. Other than that, there are no other courts that are established. How do they get established? How do we have the federal courts of appeal, the district courts where the trials begin and work their way up through the federal courts of appeal? How do we have bankruptcy courts or admiralty courts or other kinds of courts that are created in the federal system? All of those courts are created solely by Article 3, which says all the inferior courts shall rest in Congress. It's Congress that creates these other courts. It's Congress that created all of the federal courts of appeal, and Congress can abolish them or limit them or expand them. It's Congress that creates all of the lower district courts, and it's Congress that creates the bankruptcy courts and the admiralty courts to deal with maritime issues and other issues such as taxation. All of these are created by Congress. Congress can create courts. Congress can expand the number of courts. Congress can limit the authority of those courts and limit the kinds of things that those courts decide. For example, these tax cases go in tax courts, and Congress has made that determination. Tax cases don't go in other particular courts outside of taxation. Bankruptcy courts go to the bankruptcy courts or the bankruptcy judges. In admiralty courts don't go in your normal federal district court. They go in the admiralty courts before an admiralty judge. All of that is created by Congress. So there are certain things that obviously Congress can create, and there's certain ideas or issues or subject matters that Congress can limit or specify that these individual courts decide and consider. The only court is the United States Supreme Court that's established by Article 3. Now, this is similar in the individual states, where the state constitutions established the court of highest or last resort. Oftentimes we refer to those courts in the individual states as the Supreme Court. In the state of New York, however, the highest court of that state is not called the Supreme Court, it's called the Court of Appeals. And in fact, the lower court is the Superior Court. So it's a little different in that state, but the idea is still the same. The nomenclature is different, but the setup is still the same. It patterns what we have at the United States Constitution. Now, one of the things that we've clearly talked about, and one of the issues that are of a concern to all of us, is the role of the judiciary. The judiciary was established as the weakest branch of government. Why was it the weakest branch of government? Well, because it didn't create the laws. The legislature creates the laws. And it can't enforce the laws. It can't even enforce its own orders. The executive branch enforces the orders of these courts. Without the executive's cooperation with the court order would simply be a piece of paper, an opinion of a judge or judges, but it would have very little enforcement power without the cooperation of the executive branch putting that into implementation. Thomas Jefferson said that the judiciary had the seeds of the dissolution of the republic. What did he mean by that? He meant that in the federal system, these judges, they're appointed essentially for life. Now, the Constitution says that they hold their office during good behavior. They can be impeached. The impeachment begins in the House of Representatives, and that is the House that gives the essential indictment, if you will. It moves over to the United States Senate, and they give the conviction.
The courts are out of control. They are not paying any attention to the Constitution anymore. They're doing what they want to do and what their personal will is, and that they need to be held accountable.
One of the judges from the federal bench that was impeached, and there's been very few in American history, is a judge from South Florida, was impeached because of some issues that took place with regards to parties that were before his particular court. Well, that judge, interestingly, is now a member of the United States House of Representatives. So the people in South Florida, even though they knew he was impeached, they elected this individual to be a representative in the United States Congress. Congress has the authority to remove judges or to begin the impeachment process for a wide variety of reasons. And it's not limited to simply a violation of civil or criminal law. But Thomas Jefferson was concerned with these judges that have essentially almost a lifetime tenure absent impeachment or retirement, that they had to be self-restrained, that when issues came to those courts, since they're no longer responsive to the people after they're put into that position, that they have to be self-restrained. They can't reach beyond the case and create law. If they do, the other branches of government has the duty to absolutely bring that branch back into line. Either the legislature can pass laws to counteract what the Supreme Court or the federal courts have done, or the legislature can proceed with impeachment proceedings. On the other hand, the executive can refuse to enforce certain laws. Thomas Jefferson actually found himself in that very situation, where he refused to enforce certain laws that ultimately were passed, in this case, by the legislature. And Abraham Lincoln suggested something similar, and Andrew Jackson as well.
Our courts are completely out of control, and they are actually putting forth legislation from the bench. And there needs to be a balance of powers where when these judges are making rulings that are unconstitutional, that our Senate and the Congress need to actually impeach these judges.
What we see is when the legislature doesn't act and the executive doesn't act to bring the judiciary back into its proper role and function, the judiciary becomes this all-powerful entity. And today, within the last week of June, we're all waiting every year with bated breath, wanting to find out what the Supreme Court of the United States is going to say about a particular decision. Are we going to have this particular right? Or are we going to lose this particular right? That is not the way this system was established. That is going towards the fears of what Thomas Jefferson saw in the future. That is a court that has gone far beyond its power. The Supreme Court and the federal courts were never designed by the founders, never envisioned by the founders, to be these engines of social change that dictate social policy like abortion and marriage and other issues onto the American public. Because there's 9 justices of the United States Supreme Court. Only 5 of those justices are necessary for a majority opinion. So consequently, those 5 individuals wield enormous power if their power is not checked. What we've seen through history is that the judges, not only at the United States Supreme Court, have issued their own opinions and ideology, and we haven't responded to bring them back into check. A couple of decisions include Dred Scott. In that decision, that case was written by Justice Taney. Justice Taney had conflicts with Abraham Lincoln over the issue of segregation and slavery. And in that case, Dred Scott sought relief from the United States Supreme Court. But Justice Taney said, sorry, Dred Scott, you're not going to get relief in this court because you're not a citizen. And he said that blacks are inferior citizens or human beings. How dare he say that? That was not consistent with the Constitution or the rule of law then, and nor is it now.
In the 1920s, in the case of Buck versus Bell that came out of the Commonwealth of Virginia, Justice Oliver Wendell Holmes Jr. had a case involving Carrie Buck, who was forcibly sterilized by the state. She took her case to the courts and ended up in the United States Supreme Court to seek relief from this injustice. However, Justice Holmes said, sorry, Carrie Buck, there's no relief for you here. We're going to uphold what the Commonwealth of Virginia did through its eugenics law. Why? Justice Holmes stated, 3 generations of imbeciles are enough.
In other words, if the state wants to prohibit you from procreating because they don't want to have subsequent, quote, imbeciles, close quote, born into their state or their jurisdiction, then they have a right to do so. That too was a bigoted opinion that was not consistent with the Constitution or the rule of law, and unfortunately that particular ruling ultimately gave fodder to Adolf Hitler. The law in Virginia, now that it was affirmed by the United States Supreme Court, was used as a model for eugenics during the Nazi Holocaust. And Buck versus Bell was cited in defense of the Nazi regime during the Nuremberg trials. If the United States, they said, could uphold a law that was a eugenics-based law, then why were the Nazis being held responsible for what they were doing? That was part of the argument. And of course, we've seen other cases from the United States Supreme Court where the people in the executive have not responded appropriately. The biggest case is the 1973 Roe versus Wade case, decided on January 22, in a decision of 7 of the 9 justices ruling that there is a so-called constitutional right to abortion, or a constitutional right to kill the offspring, the most vulnerable in your womb. That clearly was not consistent with the Constitution, and it was inconsistent with the rule of law. And as a result, millions and millions of babies have died as a result of that decision. The legislature should have responded. The executive should have responded. The people should have responded and said, enough is enough. This court has gone beyond its authority. But when left unchecked, power that has been obtained, if it's not checked again, is a stepping stone for more power. And now we're at a point in history where the judiciary is ultimately the most powerful branch in the United States government. That needs to be changed, and the power of the courts needs to be checked so that it comes back into line with the vision of the Constitution and the Founding Fathers.